Today, we will talk about how to transfer property after death of parent. Let's have a look at the details. The death of a parent can be a traumatic and difficult time. However, if they left you some of their property, you may need to go to court to get that property transferred into your name. The process you'll use varies depending on whether your parent had a trust or a will. If they left behind a small estate and didn't have a will or trust, you can use an affidavit to take control of the property without going through probate. Regardless of how you transfer the property, you can't get started until you have a copy of your parent's death certificate. The first step is transferring property out of a trust. Go over the trust documents. Typically, the trustee will notify you within a couple of months after your parent's death. This notice includes information about your parent's trust as well as a copy of the trust documents. These documents detail the property your parent left in the trust and list the people who are beneficiaries of the trust. Contact the trustee named in the trust. If your parent's trust names someone as trustee, they will be responsible for settling the trust and distributing the assets. If your parent had a living trust in which they were the trustee, you'll be looking for the successor trustee. If you are listed as the trustee, hire an attorney with experience in trust to assist you. They'll make sure you follow all the legal requirements and fulfill your duties as a trustee. Wait for the trustee to pay creditors and taxes. The trustee is responsible for sending a notice to creditors and paying all the debts and taxes owed by your deceased parent. In some situations, this involves selling assets from the trust to pay what is owed. With the typical trust, this shouldn't take longer than a year. Complete any necessary documents to transfer the property. The papers must transfer property after all debts and taxes are paid, depending on the property type. For most personal property, no documents are needed to transfer ownership of the property. However, you will need documents to transfer real estate ownership or titled property, such as cars or boats. The second step is to going through probate. Read your parents' will to determine what property was left to you. Reading your parents' will can be a difficult task mentally and emotionally, especially if the two of you are close. You might want to get a friend or loved one to sit with you as you read it. Generally, they will list your parents' property and the specific items they want to leave to specific people, if any. Some wills are relatively short and simply leave all of the person's property to one person, while others are more detailed. Calculate the value of your parents' estate. Courts have different requirements for probate depending on the value of your parents' estate. If your parent left few assets, you might be able to use simplified procedures that don't require as much time and effort as the full, formal probate procedures. Assets that don't have to go through probates, such as life insurance policies or retirement accounts with a named beneficiary, aren't counted towards the value of your parents' estate for probate purposes. Identify the personal representative of your parents' estate. Your parent's personal representative is the person who will be responsible for the administration of their estate, including paying their creditors and distributing their property. If your parent has a will, they likely named the person they wanted to be their personal representative. Choose the correct probate court. Typically, you'll use the probate court in the county where your deceased parent lived. If your deceased parent owned property in a different county, you might also be able to use the probate court there. Submit your parent's will to the clerk of court. Some probate courts require you to submit the will you want to be probated before you file an application or petition to start the actual court process. Call the clerk's office. They'll be able to let you know if you need to submit the will and what the specific process is for doing that. Complete an application for probate. The probate court you use will likely have a form that you can fill out if you're using simplified procedures. For formal probate, you'll typically have to hire an attorney to draft a formal petition. Hire an attorney to assist with the administration of the estate. If you were chosen as your parent's personal representative, you'll typically want to hire an attorney to help you. The attorney's fees are paid by your parent's estate. Attorney's fees for estate administration are typically determined by state law. In some situations, the judge might also order a set fee. Attend court hearings as necessary to distribute property. With simplified procedures, you typically only have to go to court once. However, if you end up needing formal probate, you'll likely need to attend several court hearings for the judge to approve the distribution of property. Formal probate proceedings can take anywhere from 6 months to a year for more complex estates. Expect it to take longer if your parent had a lot of debt, or if they had a substantial estate with numerous investments. The third step is completing an affidavit. Create a list of heirs. List all of your parents' living relatives and show your relationship to them. If your parent died without a will, typically you need to be their next of kin if you want their property transferred into your name. If you are not the next of kin, or if you have other siblings, you'll need letters or affidavits from them stating that they have no interest in the property. Check with banks or other institutions for an affidavit form. Many banks and other institutions that might have control of your parents' assets have their own affidavit form. Using that form makes it easier to get your parents' property because the form includes all the information the institution needs to release the property to you. Fill out the affidavits that you need. The affidavit requires you to provide information about the death of your parent and any proceedings that are being conducted in court or have already been conducted in court regarding their estate. Typically, if you're transferring property using an affidavit, there won't be any court proceedings. You'll also need to provide details about the property that you want to be transferred to you. Gather ownership documents for the property. In addition to your parent's death certificate, the institution holding the property needs proof that your parent owned the property you're trying to take ownership of. Generally, the institution will tell you exactly what documents or information you'll need. Submit your affidavits to the relevant authorities. For titled property, such as cars or boats, you'll typically submit your affidavit to the local title office to get the title transferred to your name. For banking or investment accounts, submit the affidavit and supporting documents to the financial institution that's holding the account. For items of personal property that don't have a title or other documentation, usually, you can simply take it. You might consider getting a friend or family member to come with you to help clean out their place, or at least to be there for moral support. There are some warnings. You typically have to wait at least a month after your parent dies before you can take ownership of their property. Different states have different time requirements. Thanks for watching. Please don't forget to subscribe to our channel.